Hi everyone, I am with Mr. Andrew Pullen, who is a barrister with Founded Court Chambers, and he is in Singapore at the moment, and also a counsel for international commercial arbitration. Andrew, thank you for being part of the podcast.
Well, thank you.
But tell me honestly, what is the India-Singapore kind of story over here, and how does India feature in international arbitration in the practice that you do, and then and vice versa?
Well, I think over the years, Indian clients have been a big user of arbitration in Singapore, and you see that in the numbers. So the statistics of the institutions in Singapore, India has been, it was at the top for about 5 or 6 years in a row. It's still one of the top 3 users of arbitration at the SIAC. For instance, you see it in ICC cases, you see it more generally. In my practice, I've been in Singapore for about 13 years, and I think over that time, almost all of that time, I've had at least one India-related case, one way or another, either acting for an Indian client or an Indian party on the other side, or in recent years also sitting as an arbitrator with Indian parties involved in the disputes. So it's a major part of the arbitration scene in Singapore.
Now, you gave me a very nice segue to another thing that I wanted to ask you, which is the cultural differences in mediation and arbitration. I have a background as an in-house counsel, and I know that you need to have a certain level of comfort. You need to know that your arbitrator or your mediator understands your dispute, but that's not just a dispute, even the context of your dispute. And in the question of context, cultural differences become very, very important. What is the importance, in your opinion, of cultural differences in an arbitration or a mediation setting, especially when we talk about international commercial arbitration?
I think there's a few different ways in which cultural differences come up. One is actually in the background to the dispute. So I can think of quite a lot of arbitrations over the years that I've been involved in where when you look at how the dispute has developed, some things have perhaps gone wrong from a business point of view, but then if you have parties from different parts of the world with different cultures, they sometimes end up talking past each other, and then that makes the dispute worse. It makes it more difficult for them to settle it, and that's why perhaps they've ended up in an arbitration. And so sometimes when you're actually going through the material, when you're as counsel kind of looking through the documents or speaking to witnesses to understand what happened, you've got to take that into account and sort of understand how that's played into where you've got to in terms of where the dispute is. So that's the first way. I think the second thing is then in an arbitration itself, there can be cultural differences, obviously, between the various players within the arbitration. That's not just the clients now, but perhaps the lawyers, the arbitrators. And as counsel, I think you need to think about the legal background as well as the nationality or national background of the arbitrators, what their expectations are, what they might want to see, what sort of style of cross-examination they might think is appropriate, what sort of points they would expect to have been put to witnesses. So, for instance, if you have common law trained lawyers from, say, the UK or Singapore, they're likely to think that if you've got allegations of personal wrongdoing, they should be put to a witness. It may be that arbitrators from other parts of the world might think that is not appropriate or should be done in a different way. So I think that's the second thing. The third one is then in relation to mediation, where I think cultural differences, and primarily again here now the clients perhaps come to the fore in terms of how you approach it. So in some countries, parties may be more reluctant to mediate, or they may approach negotiations in a different way to parties from elsewhere. And of course, a mediation is essentially a kind of facilitated negotiation. So I think there you may, if you're representing parties, you may need to work harder with parties from some countries to get them comfortable with the idea of doing a mediation. And once you're in the mediation, if you've got parties from different countries, then you want a mediator who is aware of those cultural differences, is able to sort of see past them or understand them, if he or she is going to bring the parties together in a way which is going to help you solve the dispute.
But how do you solve for this? When you have, say, you need a particular kind of sensitivity to a matter, how do you solve for this?
So I think appointment of arbitrators is a very good example of where you need to take this into account. So if you've got two parties from Asia, if you then select an arbitrator who's got no experience of Asian disputes, then they are probably going to be less well attuned to the particular ways of doing business in different places. So that can be kind of culture in a sort of general sense. It could be more specific elements of business culture, how much is written down, how much documentation is retained. That's often an issue, whether an arbitrator is going to immediately infer that documents have been hidden if they're not produced, or whether they're going to understand that the way in which business works in a particular country, it doesn't have the same level of record keeping as somewhere else.
Yeah.
So I think you do take that into account when you're selecting arbitrators. You think about what their experience is. So that may or may not mean that they are from that particular country, but I think what it does mean is you want to select people who've got experience of arbitrating in the part of the world where your client is from. I think that's very important as part of arbitrator selection.
So what I hear you say is whenever you're getting into an international commercial arbitration, there are so many considerations that are required, which are much more than just the facts and the merits of the matter.
Yeah. It's a facet of the facts, I think, that the parties are from different places and that they have a different cultural background. So whenever you're selecting arbitrators, you're not trying to bias the panel in the sense that you don't want an arbitrator who is biased. You want an arbitrator who you think is going to have an understanding of the sort of case that your client is going to put forward, so that there's no misunderstandings and so that they have an appreciation of the background. Yeah.
Would you say that the same considerations would apply to a mediation proceeding as well?
I think it probably does apply. It's slightly different because in a mediation, you can have mediations with more than one mediator, and sometimes that might be useful. So if you do have parties from very different cultures, it could be a consideration to appoint a mediator, one from each, to try and help that understanding be facilitated. But it's slightly different because the mediator is basically working with both sides to try and bring them together. So it plays out in a different way. In the arbitration, it's more about making sure that you think you've got at least somebody on the panel who's going to have an understanding of the background, the context. And as I say, that could be the documents, it could be the demeanour of witnesses in the witness box, whether they answer questions directly or not. So in some cultures, thinking about Japan, for instance, I think that people perhaps don't start with the yes or no. They go and then explain it. They tend to start with the explanation and then get to the yes or no towards the end. And so if you get somebody that's never had an appreciation of that and is used to people answering questions in a different way, then that might give them a negative impression of the witness where that's not really warranted. So these are all the sort of things that you think about.
Okay. One last thing I wanted to ask you is the general trends that you see in international arbitration, either going out of India or coming into India. Like, where do you see India being on the map of arbitration? Because I see a lot of representation from not just our country in this ADR week. So there seems to be so much of interest and so much of sort of cross-border work that's happening. So what do you see as the future trends? Or rather, what do you see right now and what do you see as the future?
Well, as you say, there are a lot of people here at ADR Week who have come in from other jurisdictions, Singapore, London, elsewhere in Asia. And I think that's just a reflection of the fact that India is a very significant economy in the world. It's a growing economy. You have inbound and outbound investment. You've got inbound and outbound trade that is inevitably going to give rise to disputes. And so I think we're going to see arbitration with a connection with India only continue to grow as those sort of trade and economic links develop. I think we'll probably see, there is obviously a distinction. You've got the domestic arbitration scene, you have the international arbitration scene. And I tend not to get really involved in domestic arbitrations, obviously, but a lot of that is the construction and against the government and that sort of thing. The private and the commercial arbitrations, I think that's a much bigger portion of what you get in the international arbitration. I suspect we'll sort of just see those elements continue. I think it will continue to grow. I think you'll have continuing sophistication of Indian counsel, arbitrators involved in the process. And I think you'll just see a lot of, cross-pollination of ideas between practitioners here and practitioners elsewhere.
And would you say the same for mediation as well? Do you see a similar growing trend in the international space?
I think perhaps less specific to India, but more generally in Asia, I think we've seen mediation grow. I think parties in lots of parts of Asia have become more comfortable with using it. When I moved to Singapore about 13 years ago, from the UK. And in the UK, there was quite a big tradition of using mediation to settle disputes. It was noticeable when I moved that you didn't see mediation used that much for the big commercial disputes that I was then seeing over here, whereas I think now you are seeing it used more often.
Okay.
Yeah.
Okay, on that note, thank you. Thank you so much for being
Pleasure.
here.